Hey everybody, it's Thomas Kenny. I am Policy and Media here with Jennifer Pippin, also on the executive board of Moms for Liberty because she runs the whole thing here in Indian River County. I
Not
can't
true.
believe you ever
Teamwork
asked me
gets
to
this
do
done.
this. You want to get in touch with us? Hey, check this out. Let me show you some options, okay? First things first, momsforliberty.org. Momsforliberty.org. If you are outside of Indian River County, in another county that doesn't have a Moms for Liberty chapter, go here and fill out all the necessary electronic paperwork. Okay? Momsforliberty.org. There it is. We're having our national summit in June and July. You can just show up. You can take the parents' pledge if you're a candidate, all that good stuff. All right, momsforliberty.org. And also locally here, we can do on Facebook, Moms for Liberty Indian River, Florida public page. So just look for us. Type in Moms for Liberty Indian River and you will get a hold of us. All right, and join a growing page where you get access to everything happening locally and a lot in Brevard too, right? With our friends
Yes,
in
we do.
Brevard and Martin County. So
And
that's
sometimes we'll post national stuff on there too, if it's something big that could be coming to, our state or our county. Just tons of information. And if it's not something that interests you, you could just keep scrolling.
Yeah, just keep scrolling. You will find something that interests you if you're interested in education. That's what
That's
I
right.
do know. Anyway, last time we were here, we started unpacking the desegregation order and how if we look at the 67 desegregation order, we would find that our school system has already reached unitary status. The infamous unitary status that has been eluding us for 59 years. My position, and I'm sure yours is too, it's not that it's been eluding us, is that we've been eluding it. We find more excuses not to be in unitary status than in actually being it. That to me is important. And you asked a really important question last time. Hey, so what happened after the 69 order, the plan came out? We talked about that plan, the eradicate all aspects of a dual school system in 1969. You're like, what happened? What happened to those next 3 decades? Well, that's a very interesting question because the school system did have to report to the judge, their progress, and based on their plan that they submitted in 69 and was approved. 1994 comes along, and there's not a lot of court visits that I see on the docket from 69 to 94. But 94 is a pivotal year in all of this. First off, the NAACP becomes the plaintiff. So it's not individuals anymore that first filed this complaint and won their case, and the defendant had to do something, and the defendant was charged to make a plan, and the defendant made that plan. Now it's the NAACP versus the defendant. You can sort of see where this is going. And 94 comes about, and they're like, hey, the school system has grown up. We now have 13,000 students where we once had 8. It's all in the plan. Talks about all that. Talks about the history of the desegregation order and the 69 approving plan. That has to be modified because the school system actually in 1995 wanted to implement a whole middle school system. They didn't have one. They basically had elementary, they had Gifford Middle 6 and Middle 7, where everybody went, and then they had a high school. And now they want to do a whole middle school system. There was this whole idea of a school being put up in Sebastian, North Sebastian Middle or something. And therefore, they wanted to redevelop the plan. So the NAACP and the school district got together and created the joint plan in 1994. And you're like, well, what is that? Now you have a plaintiff and a defendant in a case creating how restitution is to be made. It's not like a traditional court case where the judge says, you're in the wrong, sir defendant, sir board of instruction of Indian River County. You need to do this, 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 and this. How are you going to do that? And so the school system submits a plan in 69, says this is how we're going to accomplish that. It's not doing that anymore. Now it's the NAACP and the school system coming together and creating a plan. And then the judge says, okay, you guys come to a contractual agreement. I approve it based on what you have here. Looks good to me. Judge is not making a decision. All the decisions now are being made by the plaintiff and defendant together in a room. This is going to prove something. And so I want to share what that, I don't necessarily want to talk too much about the plan, but I want to share what's been happening with this desegregation order. Because we talked last time about how these policies are being made that are, and the reason behind it is, well, we're in a desegregation order. We're overseen by a judge and, we need to show the court, blah, blah, blah. We don't need to show the court anything. These things are being done to try and get the other side to agree so we can get out of it. And then the judge would go, yeah, you guys agree. Done.
And it's still being handled that way today. So, it's not going before the judge, to rule, like you said, in a traditional case where it says, yes, you've done this, or no, you haven't done this, and here's what you need to do. It's getting handled between the school district, still to this day, and the NAACP. So you're exactly spot on.
Well, let's see what the 94, and I want to emphasize this point. So here's the plan as it was presented to the court. This cause arose based on the parties of the joint motion requesting approval of revised order approving plan. That's a bunch of gobbledygook for legal scholars. The school board of Indian River County, hereafter referred to as school board, and the NAACP Indian River County branch, hereafter referred to as NAACP, requests this court's consideration and approval of a revised order approving plan. This is the 94 plan, which has been negotiated and approved by the remaining parties to this case. The court, having considered the joint motion of the parties, the facts, the record, the plan as presented in the motion, and the history of cooperation of the parties, does hereby. And then it goes on, shows the facts, so on and so forth. So the court does therefore order and adjudge that the following plan of organization of the school district of Indian River County, Florida, is approved. So they negotiated the plan, they wrote the plan, they sat down together, boom, and the judge approves it. Judge doesn't make a decision anymore. Judge just agrees to the decision reached by the two parties. And this goes on and on. There's minority teacher ratios. This is something that has changed. Last time we talked, it was at least 2. And minorities were black or white, based on which school they were going to, which segregated school they were going to, an all-black school or an all-white school. Now it's minority, ratio of minority students in the student population. So the language of civil rights has changed in the 30 years since this case started. In 64 and those eras, it was about integration, no more white countertops at bus stations and malt shops, and no more black countertops, no more black and white bathrooms, so on and so forth. We all know the story. But here, everything has changed. It's now about minorities, majorities. Very different. The impetus of traditional civil rights is, the language of it has completely changed. And that's where we are today. That's a significant thing. We look back on civil rights to validate this. Here's the big thing that I want to bring home about this. The planned supervision. The school district will continue under this revised order approving plan while the plan is implemented. This will maintain an avenue for dealing with problems should any occur in the process of implementation. Here's the avenue. The parties agree that the changes to this plan may be made in writing and upon mutual agreement. The parties agree This thing could go on in perpetuity right there in that statement, because this is still happening today in the 2018 plan. Hey, we can make changes in writing and upon mutual agreement. The 2018 plan has been revised already. That's why we have a work group as opposed to a committee. More on that later. The parties agree to continue to work together to provide for the changing student and adult populations of Indian River County. Demographics. Once again, you're trying to meet percentages of minority teachers against your minority population, and you're not coming up to, right now we have to be plus or minus 3%. Teachers plus or minus 3% to how many students based on ethnicity. And demographics change all the time. If either party feels there is a need to meet any of the issue relating to this or subsequent plan for desegregation, they shall notify the other and make arrangements through their appropriate officers to meet and discuss the issues prior to the need for court action. Hey, work it out yourselves. If there is a dispute over any issues relating to desegregation, be it an issue covered in this plan or one not covered, every effort shall be made to handle those issues between the parties without the necessity for court action. Mediation methods and techniques shall be employed where meetings between the parties are unsuccessful. The parties to this case and their successors have enjoyed a long relationship of cooperation through negotiation and settlement of their disputes by agreement. It is the intent of this plan to continue that relationship through a commitment to meetings and negotiation rather than litigation, rather than going to court. And there's our famous judge, C. Clyde Atkins, 1994. He's presided over this case now for 27 years. Actually, about 29 years. I think he came on in 65 when that amendment came about. There you are.
That went back to my other question of, during our last session was, what happened in that 30-year period? And I know we're waiting for more public records requests, but so, up until this point, until we get that documentation, nothing was done. We didn't reach unitary status. So now that we have this new plan, what happens next, Thomas?
Well, this is interesting. So in 94, this happens, and C. Clyde Atkins, who's been on this case for the whole time, presiding. But you see, he's like, don't come to my court if you can't agree to something you just agreed to. Don't ask me to settle it for you. The judge is not going to make a political decision. He's going to adjudicate a legal decision. Well, you've set the parameters between NAACP and the school system have set their own legal parameters. So he's just looking at it going, I'm not going to dispute any of this. I'm not going to judge on it. You guys come to an agreement. And if you can't do it amongst yourselves, go to mediation. Here are your mediators. I assign you mediators. That's when it gets expensive, very expensive. And they go to mediation. And then in mediation, they work something out. Anyway, Judge Atkins, very historical figure in our county, even though he's down in Miami, dies in 1999. Now, from 94 to 99, there's like one thing. Someone filed a complaint saying they were discriminated against. It went nowhere. It was a teacher, I believe, in 98. 99, the judge dies. Nothing happens from 99 until 2016. 17 years, this case was ignored, even by the feds. The plaintiff, who seems to have the biggest interest, the NAACP, did nothing. They didn't, hey, federal government, where's our judge? They didn't ask. No one paid attention to this. We got a 94 order, and no one's paying attention to it. For 17 years. So much so, the federal government, the U.S. federal district, closed the case. They didn't even assign a new judge upon the judge's death.
Wow.
Now,
so nothing was filed, nothing was done, nothing was said. It was
until 2016.
So even so much so. Right. That the federal, they were like, okay, that we're going to close this because nothing's been done for almost 20 years. Wow. That's big. That's big because, if you're in my case, Thomas, and you're trying to make it fair, you're trying to get this under wraps, like you would do something, you would keep up with it because it would be a priority, which is very interesting that nothing was done for that long of time, in my opinion.
And you think about it up now, you say, well, what happened in 2016? My understanding, and I have to verify this, is that some members of the school board at that time, in like late 15, along with the superintendent at that time, would that be Rendell? I think in 15?
That I'm not sure. Sure. We'll have to wait for that public records request to come back.
had saw that, hey, we've got this deseg order sitting here that seems to be just no one's paying attention to it. We should probably pay attention to it and ask for unitary status. In other words, they took responsibility for something. I don't know who it was exactly. We're still trying to figure that out.
Right.
And therefore, they started the process up again. And at that point, the federal government's like, we haven't assigned a judge since the Honorable Clyde Atkins died in 1999. So that was the first order of business. They had to put a judge on it. And Anthony Brown over at the NAACP was like, well, you don't have unitary status. We haven't agreed to that. But neither one of you guys have been paying attention for 17 years either. Definitely the NAACP.
Well,
Go on.
Yeah, I was going to say, if the school board didn't bring it up, I mean, we could still be in that boat today where it was just dormant for almost 20 years.
Absolutely. Wow. So there was a good faith gesture made, and Susan DeAgressa, our attorney at the time, filed for unitary status, I think on 3 of the 5 measures in the 94 plan. And they went to me, and the NAACP went to mediation, and this took forever, and it ultimately ended up in the joint action plan of 2018 that we have, which is a rewrite of 94 with different language, different goals. Again, here we are. And the current judge, or the judge that took over, I don't know her name at the moment, it escapes me, says, okay, you guys agree? Boom, boom, boom. The management of the case is still the same. The plaintiff and the defendant coming together once again and saying, Judge, we want to do this 2018 joint action plan. Do you guys agree on all this through and through? Yes, ma'am. Okay, I approve. Go do it. Same discipline to be applied as in the 94 plan. You guys get in a dispute, work it out. You guys don't work it out in your own dispute, here's a mediator. Go to the mediator, work it out. If you change anything in your discussions, let me know about it. I'll sign off on it. And that's what she's basically has done for the last 7 years.
Wow.
People say, well, we've been in this for 59 years, and they use it as a hammer on the school system.
Right.
Saying it's racist or whatever. That they can't even desegregate it.
Right. Well, and it makes it look like us as a school system, meaning the students, the teachers, the faculty, the community, has not been able to reach an agreement with the judge, a lot of people thought, myself included, until you go back and you look at the documents and see that it's supposed to be worked out between the NAACP and the school district. And, even local media today is saying, well, the judge, or the federal case, when that's not even the case. It needs to be worked out between the two parties. And then
let's pull up something about that. I mean, I could show you here in the latest article at Ray McNulty News, on our clown show antics about Moms for Liberty.
Which this was completely false. Yeah, because it has nothing to do. This policy that is being repealed was written in 2020. And it never went before the judge, correct, Thomas? The judge never saw this. It's not integrated into the desegregation order.
Exactly.
So this is completely false.
Exactly. So, and they were talking about your email to the Department of Education about, hey, they're not removing it at your request. And McNulty writes this: somehow her email also omitted the fact that our school system remains under a 1967 federal court desegregation order, and that our school board is caught in the middle of a legal tug-of-war between a U.S. district judge and the state. First off, the state's not even involved.
At all.
At all. Secondly, the judges made it very clear that the legal tug-of-war is actually between the NAACP and the School District of Indian River County coming to an agreement.
And it has been since 1994.
It actually probably, the NAACP always represented in this case, is my understanding, as the legal, even when it was individuals. That's why the case is still titled Sharpton et al. They've just taken over because I think some of these people have passed away.
Including the judge.
Including, yeah.
Right.
Yeah,
I mean,
including
honestly,
the judge.
Including the judge, right. I mean, it's...
yeah, and
that just baffles me.
It baffled me when I found out about it. I was like, what? And they actually, the feds, because there was such inactivity, the feds... I mean, there are reports that need to be made and showed to the judge. None of that was done.
Right.
There was just inactivity, so much so they were like, hey, no one's calling up the court here. Well, I guess this is closed. We're going to close it. They had to reopen the case.
Wow.
So you think 17 years, 27, 25. I'll go from 69 to 94, 25. Because look, the proof of us being in this under this deseg order is about the participants in the case. It's not even about the judge. It's not even about Mr. Honorable Atkins. It's not about him, because you guys have an agreement to work out. It's taken you, NAACP, and you, School District of Indian River County, 59 years to figure this out. It hasn't taken the judge. It hasn't taken a U.S. judge. The U.S. judge told you back in 67 under the amended thing, when those people actually filed for an amendment, hey, do these things, which if you look at our school system, they're done. But it's taken 59 years between these two parties, and thousands and thousands and hundreds of thousands of dollars. We're in the millions of legal fees.
Right.
No doubt in my mind. There have been motions filed by citizens saying, superintendent spent $775,000 in a year on this case. For the purpose of what?
Right. Well, and we were told, too, that the NAACP is not incurring any charges because their lawyers are doing it pro bono. So it's costing is taxpayers. It's
costing taxpayers a fortune. And I'm like, well, why would they do this pro bono? What is the purpose of this? Right. That's my question. And I want to know. I know Marshawn Green is on the work group, and we're going to talk more about this. We're running way long. We can go on and on.
Sure.
But
we'll
there
do
are
it
people
on our next episode. We'll do an update.
Yeah, and we're going to return back to some of these policies, I think, because there's questions of critical race theory, which Marshawn Green will tell you is a legislative theory. It's not a legislative theory, it's a legal theory. My bad. But it's being practiced right here. And that's why we're getting these policies. We're getting these weird policies that still say the school system's systemically racist, when that same writer who wrote that thing we showed from Vero News said last year that we're a minority-majority school system. I have it.
Well,
There it
and the
is.
biggest thing too, yeah, is this 2020 policy that is being repealed was not part of the desegregation order or this court case in any way, shape, or form. Nor will this, new policy that's being brought up be put in it either, because this desegregation order and the 2018 joint plan is prior to all of these, policies being implemented, which is huge because most of the public and people that I talk to don't know this. They just, again, see it on the news or they hear it from the dais and don't know the facts and haven't done the research like you've done, Thomas, where you're pulling these cases and you're looking at the information and they're not giving the factual information, which is why it's so important to know before these policies are implemented or before they're repealed, to know, the basis for these policies.
Absolutely. Well, we'll do that next time. We'll talk more about this, and have a good one, Jennifer.
All right, you too. Bye, Thomas. Bye,
Bye.
guys.